Good evening, everybody, and thank you for coming. My name is Rita DeBoer. I'm Vice President of Programs for the ACC Chicago chapter this year, and I want to thank you all for being here on this freezing cold night. We're looking forward to another good program by Brinks, and they've been a sponsor of our ACC Chicago chapter for years, and they're going to be continuing next year. We very much appreciate their support. I wanted to do a quick hello to the other board members who are here, so that if you would please stand up. And what we'd like is so that you know who they are. If you've got any questions about ACC or if you'd like to get more involved, we encourage your participation. And again, thanks for coming. I'm going to turn it over to Mary Squires from Brinks at this time.
Thank you, Rita. I'm Mary Squires. I'm a shareholder at Brinks. I think I was picked for this function because I have more gray hair than any other Brinks person here. So I guess that makes me senior for the moment anyway. Scott and Howard and Winnie are going to talk about a very timely subject tonight. If all of you were on the internet yesterday, you saw Google with their duct tape on their mark, which I just thought was really hysterical. And Wikipedia went off the air yesterday, and all of this was a defense of their First Amendment rights. And notice they did it with their trademark, folks. It really all is in a name, and that is what Scott and Howard and Winnie are going to explain to you tonight. And before I introduce them, though, I really do want to thank all of you for letting us sponsor your events. Many of you came up tonight and expressed strong appreciation for that, and we really do appreciate that from you. And we enjoy working with this group, and we look forward to a long relationship in the future. So thank you very much for that. So Scott told me I had to be brief. So let me tell you about Winnie, Howard, and Scott. Winnie is one of your members, of course, and she is currently in-house at Morton Salt, you know, the little girl with the umbrella, very important trademark. She's been there since 2009, but she has been in the corporate world for over 12 years. She did work in a law firm for a while, but I'm not going to mention that because, you know, I'm not going to mention the name of another law firm. That just doesn't make any sense from my perspective. She also worked for UBS for a while before she came to Morton. She went to Washington U in St. Louis for her law degree. She also has a JD in tax from Northwestern, and she got her BA at Yale. So her practice now is involved in overseeing the trademark portfolio for Morton, but she was explaining to me earlier tonight she is a generalist and does many different areas of the law there, as of course many of you do in your practices in-house. By the way, I used to work for Sears Roebuck. I started there for 9 years, so I still refer to myself as outhouse. I want you to know that. Thought you would appreciate that. Now, let me tell you about Howard, who is also known as Howie. He's kind of AC/DC with this. He's never decided which name is appropriate, so I never know, am I going to introduce him as Howard or Howie? So it's both. And Howie is a shareholder at Brinks. He's been there for a number of years. He is involved on the trademark side. We do tend to draw a line at Brinks. There's the trademark group and there's the patent group. There's a couple of folks who are AC/DC, but the people who are in front of you tonight are primarily trademark people. And Howie works on enforcement issues globally. He's been involved in many actions that our clients have been involved in throughout the world. He's also involved with internet issues, trade dress issues, false advertising, counterfeiting, and the Trademark Trial and Appeal Board. So his practice is rather widespread. Scott is also a shareholder at Brinks, and he is also involved internationally, doing quite a bit of management of international and global portfolios for our clients. He is very much involved in managing a number of large portfolios and is involved in all issues that come up for these people on the trademark side. He also has a specialty in internet litigation, especially focused on social media issues. And with that, I turn it over to them. By the way, Winnie's last name, she is also AC/DC. She is Kuo or Kuo.
Thanks, Mary. Okay, so imagine this scenario. John from marketing comes running into your office with the greatest name for your company's new computer keyboard, and he wants to call it the 101 key keyboard. So you think to yourself, that's kind of interesting. It's got a number in it. You haven't heard it before. But then you think to yourself, wait a minute, John's not that creative. So you ask John, that's an interesting name. Where did you come up with it? And John stands in front of your desk with a big smile on his face, and he says, well, because it's a standard U.S. keyboard and it has 101 keys. He figures the name's perfect because it easily conveys to consumers the benefits of the product, namely that it's a standard U.S. keyboard, and it'll easily fit in your company's soon-to-be printed catalog, and he's excited because he can easily register it with the trademark office and enforce it against every other competitor that wants to use anything similar to it. Well, now you start to realize that you're going down the same old road again. You're going to have marketing on one side trying to use and protect a relatively weak trademark, and you're going to be on the other side with the legal department trying to set marketing's expectations and protect as best as possible a weak trademark. So what are the issues at play, and how can you best handle this situation? Let's take a look. When analyzing whether or not you can protect a trademark, you have to evaluate the trademark's strength from where it falls on the spectrum of trademark distinctiveness. And prospective trademarks fall within one of 5 categories, from strongest, meaning the easiest to enforce, to weakest, meaning the hardest to protect. First up are the strongest marks, and these are called fanciful trademarks. They're made up words that didn't exist before they were trademarks. So an example is Reebok for shoes. The second strongest trademarks are called arbitrary trademarks. Arbitrary trademarks take a pre-existing word and use it in connection with goods that have nothing to do with that meaning. So for example, there is an Amazon rainforest, but Amazon would be considered an arbitrary trademark when used in connection with internet shopping services. The third strongest trademarks are called suggestive trademarks, and these trademarks indirectly allude to a quality of the product that they're used in connection with. So an example would be 7-Eleven for a store that's open from 7 a.m. to 11 p.m. All of these 3, fanciful, arbitrary, and suggestive, are immediately registerable with the trademark office, and they're considered distinctive the minute they're first used. Problems start to creep in, however, when you select a trademark from the next category, which are called descriptive trademarks. And descriptive trademarks describe a part of the good or service that they're used in connection with. So an example here would be, Vision Center for use in connection with an optics store. I'll focus much of this presentation on trying to help you protect these types of marks as best as possible. They're not registerable or protectable the minute that you start using them. And the 5th category is really not a trademark, but it does bear mentioning. They're called generic terms. And generic terms are terms that describe the whole class. So that would be something like milk for a white beverage that comes from cows. So I want to go over the 2 most difficult issues that surround the use of descriptive trademarks. And I want to provide you with some suggestions for dealing with them. And the 2 main ones are getting the trademark registered and protecting it, and then the second is addressing descriptive use of your mark by your competitors. So the spectrum of trademark distinctiveness matters a great deal because where your mark falls on it will have a great impact on whether or not you can protect your mark and whether or not you can register your mark with the federal government. Unfortunately, the Trademark Office doesn't just register every mark that's filed with it. Instead, it examines each application and can raise any number of objections to it, including refusing to register it because it's descriptive of the goods that you've applied for. And it will be considered descriptive as long as it describes an ingredient, quality, characteristic, function, feature, purpose, or use of the relevant goods. That can be called descriptive. So you see it's a very broad definition of what would be descriptive. It does not have to be generic to be rejected. So what can you do to overcome those objections and make marketing somewhat happy? Well, here are some suggestions. First, descriptive trademarks can achieve registration if they achieve what's called secondary meaning. And a descriptive mark attains a secondary meaning if the producer so effectively markets the product with that mark that consumers come to immediately associate the mark with only that producer of that particular kind of goods. The USPTO's rule of thumb is that if you've used a trademark for over 5 years, there's a presumption that the trademark has acquired a secondary meaning. Interestingly, though, as of late, the USPTO appears to be moving away from the 5 years of use rule and is requiring more use. I recently filed an application where the applicant had used the mark for over 11 years, and the Patent and Trademark Office still refused to accept that as a presumption that it acquired secondary meaning. Now, proving secondary meaning can be very difficult if you haven't used it for 5 years, or even in some cases if you have used it. And I want to discuss the main techniques that we've seen for trademark owners to successfully prove that their trademarks have acquired secondary meaning. And the main ways are through providing declarations, advertising, both examples of your advertising as well as figures, sales figures, surveys, and a couple of additional tricks of the trade, including adding a distinctive term, adding a logo, and getting creative with your identification of goods and services. First, when trying to prove that a trademark has acquired a secondary meaning, we'll draft a declaration for our client to sign. And we don't want to make our declaration simply state that the mark's been in use for over 5 years and therefore it's acquired a secondary meaning. Instead, you want to use the declaration to introduce the other types of evidence that are going to support your argument, including things like advertising and sales figures. In addition, we found it very helpful to submit declarations from third parties. For example, you can get declarations from consumers or distributors, stating things like they recognize the trademark in question as being source identifying. They look for the trademark when making their purchasing decisions, and the trademark is an integral part in their purchasing decision. You can even submit declarations from competitors, and these are very persuasive. If you have to enforce your trademark against a competitor, think about requiring as part of the settlement agreement that the competitor sign a letter or a declaration supporting your trademark application. We have found these to be really persuasive evidence of secondary meaning. If you use a declaration to get examples of your advertising into the record, which is a common practice, make sure that your advertising uses the trademark properly, as an adjective describing a noun with proper capitalization. If you don't use the trademark properly in your own advertising, it can really come back to haunt you. Examiners love to put into office actions stuff from your website or advertisements that they found where you're using your own mark descriptively. Next, consider providing photographs. They're a terrific way to get across to the examiner just how distinctive and well publicized your trademark is. We've presented photographs from launch parties or from sponsorship events where the trademark is prominently displayed, and the examiners have really responded to this technique positively. I mean, ask Nike about the impact of photographs of Michael Jordan dunking while wearing his Air Jordan shoes, as to whether photographs can help a trademark gain distinctiveness. Now, the next three things that I listed here, media mentions, internet traffic, and social media, can each significantly help demonstrate secondary meaning. First, keep detailed records of any and all media mentions of the trademark. One reference in the New York Times can mean a lot more to your trademark than 100 of your own references. For internet traffic, be sure to monitor your corporate Facebook and Twitter accounts. See how many people are viewing them and following you. Use your existing friends and followers to increase awareness quickly for your newest trademarks. And finally, a word regarding social media. Courts aren't immune to the impact of social media. And social media is really impacting secondary meaning, and how trademark owners nowadays, thanks to social media, are able to achieve secondary meaning in theory much faster than they used to be able to. Because when they introduce things now, they have built-in follower bases that they can show. So don't forget about how important these are and use them to your advantage. The more sales you can show that you've made in connection with the trademark, the better. Large sales figures support the argument that the product's been successful, and because it's successful, people recognize the trademark as being distinctive of your products. You want to provide as much data as you can, but know that it's not confidential. So what some clients do is they provide a range of sales figures. They'll state they sold between $5 and $7 million worth of this product, and they'll feel like they're not giving away too much confidential information, while at the same time strongly supporting a finding of secondary meaning. Another thing you want to do, if at all possible, is show that your sales are increasing. And this helps to argue that consumer awareness is only growing. Again, how you present these numbers can go a long way. Do you use a bar chart? Do you show how big your sales are in the industry so you compare yourself to your competitors? Maybe you have a very, very expensive product and maybe you only sell 100 of them a year. Well, to a normal person, that may not sound like a lot. But if your nearest competitor only sells 23 of them, well, if you're showing it that way, it can have a much larger impact on someone seeing it. So you want to be really creative about how you show this information. Consumer surveys, they're often viewed by courts as the best evidence of secondary meaning. Now, I want to be clear here. We're talking about trademark surveys, not marketing surveys. When you tell the marketing department that you want to conduct a survey, they'll say, great, we've got a great marketing expert on retainer. We can run the survey in a week and we'll get great results. Well, the problem is that's a marketing survey. And marketing surveys tend to go to favorable areas or markets of high sales or high advertising expenditures because the marketing department wants to know how effective their advertising is. Well, they don't have specific court-approved standards about how they're set up, how they're conducted, and how the results are interpreted. Trademark surveys do. Trademark surveys and the experts that run them must be set up a specific way, conducted a specific way, and their results interpreted in a specific way in an effort to gauge, in the court's mind, actual consumer understanding. If the trademark survey isn't run properly by the right person, the survey will either be significantly marginalized or could be excluded altogether. Now, that being said, if you have a favorable marketing survey already in your pocket, feel free to provide it to the Patent and Trademark Office in support of your application. I don't mean to say that you can't do that, but I'm just trying to point out that there's a big difference between a marketing survey and a trademark survey. Now, if proving secondary meaning proves too difficult, then perhaps the mark, it hasn't been in use very long at all, or it's so descriptive that it's bordering on generic. There are some other things to think about when you're trying to get it registered or protected. First, consider adding a distinctive term to it. Often clients apply to register their house mark along with the descriptive term. And if you get it registered, even if you have to disclaim the descriptive term, you can use the orange circle after it as long as you're using it with the house mark, and that alone might be enough to scare away competitors. Second, consider adding a logo to the descriptive trademark, or at the very least a distinctive stylization to it, and then try to use that logo or stylization whenever you use the descriptive trademark. Obviously the Coca-Cola script is one of the most famous examples, of a distinctive stylization. I've also put Google on here to show how colors and font, can work together to make something even more distinctive. By doing this, you may be able to get a descriptive term registered, and again, even with a disclaimer of it, that alone may be enough to scare away a competitor. Third, when applying to register a descriptive mark with the Trademark Office, it often pays to be creative with your identification of goods and services. The idea is that if you do some research on other descriptive terms that were successfully registered, you might find a pattern. So for example, let's say that wheelies was registerable as a trademark for motorized vehicles, but not for motorcycles. And let's say you wanted to use wheelies for go-karts. Well, what you could do is you could apply to register it for go-karts, but specifically not for motorcycles. And you could put that into your ID of goods. And by excluding the goods that cause the problems, you might be giving the examiner, a reason to approve your application. It's something that we've tried on several occasions, and it's really worked well. Now, other than having difficulty registering your company's new trademark with the Trademark Office, what other problems will selecting a descriptive trademark cause? Well, the second one that comes immediately to mind is that you'll have a very difficult time, if not an impossible one, stopping a competitor of yours from using your trademark descriptively. And descriptive or fair trademark use is when a competitor of yours uses your newly created trademark in a sentence, not capitalized or italicized, but instead in its primary descriptive sense. So for example, if you tried to use healthy as a trademark for your company's new hamburger, it's possible that a competitor of yours might state in its advertisements that its hamburgers are both healthy and wholesome at the same time. Our hamburgers are the best. Well, if you challenge your competitor's use, your competitor might respond that it was simply using healthy to describe its product, and that it's not liable for trademark infringement. And a court may very well agree with the competitor because courts view trademarks, much like the Trademark Office does, in that they don't want to grant a monopoly, in effect, to a trademark owner for use of a descriptive trademark. Well, so what can you do? Well, first, as we discussed, getting your mark registered, even if it means adding other distinctive elements to it, like your house mark or a logo or stylization, can help you protect that mark against descriptive use. Now note, you may have to disclaim the descriptive part, but if you have a registration, it may give you more leverage in arguing against the descriptive use of the mark. Second, you need to be very realistic about the scope of protection that's available to you. One good gauge is to see if you have evidence of actual consumer confusion, for example, in emails or misplaced telephone calls. Oftentimes, clients will come to us because they're concerned about a competitor's use of a potentially descriptive one of their marks. And after we analyze it, we decide not to do anything right away, but instead to monitor it for evidence of actual confusion. The idea being that if somebody or several people start sending in emails or inquiries about it, then maybe it's moved from the unprotectable descriptive use by your competitor to something that's actually causing a problem, and that may be actionable. Third, you want to add other distinctive elements to your product, such as a distinctive trade dress, a house color, or other marks. By doing so, you may be able to base your cease and desist letter not just on the descriptive mark, but on other, perhaps more, stronger intellectual property of your company. So sort of you're bolstering your descriptive mark with other more distinctive aspects. I wanted to add one last practice tip about trademark searching here, because sometimes clients will say, fine, Scott, and it does happen every so often. They'll agree. They'll say, you know what, it's a weak mark. It can't be registered. We'll just use it. And, we don't need to search it because we aren't going to register it. Well, I want to point out that even though you and I may agree that the mark is weak, if you're planning on, that doesn't mean that everybody else does. So instead, I often suggest that they search the proposed mark because you never know what third party could be out there and that may have actually acquired a secondary meaning in the mark that you think is descriptive. And also, and this is really the last tip, but be careful, because oftentimes marketing will come to you and they'll say, you know what? Okay, I'll use the mark descriptively. Well, one thing is ask for a mock-up of what they're really going to do, because are they really going to use it in the middle of a sentence, like the version I was talking about with, healthy and wholesome at the same time? Or is the mock-up going to show you that it's going to say healthy across the entire front of the package in a distinctive trademark way? So always ask. Don't just assume that they understand exactly what it means to use it descriptively, and make sure that you actually see it. So to briefly summarize, the first step is to always try and steer, or at least educate marketing to select as distinctive a trademark as possible. By doing so, you set your company up, going forward, to have a much easier time using and policing its marks against third parties. Another way to look at it is, if you select a descriptive mark, it's going to cost you more to register it, and it's going to cost you more to try and enforce it. Oftentimes, forcing marketing to consider the overall cost-benefit of selecting a particular trademark at the outset is a good way to try to convince them to select a more distinctive mark. If, however, you end up with the unenviable task of trying to use and police a descriptive mark, well, then the key things are to be realistic at the outset about the scope of protection this mark is going to enjoy, and be smart. And by being smart, I mean start collecting supporting materials from the day you start using the mark. I always envision putting a box next to your desk where you just are putting in stuff, that you see, media mentions, blogs, anything positive that's referring to the trademark, photographs from these different events, and keep track of all of it. It's called being proactive and being smart. Well, now I'm going to hand it off to Howie, who's going to discuss how these types of issues play out when trying to protect an arguably functional trademark.
Thanks, Scott. Before we get started, Mary mentioned that she never knows what to call me, Howard or Howie. There's a little story behind that. Ever since I can remember, I always preferred Howie. And why? Well, what does Howard rhyme with? Coward. So that always caused me problems, and I never liked it. And my dad always hated the fact that I liked being referred to as Howie, and he'd always try to get me to change it because he thought it sounded silly. So he comes out one day to law school in Boston. He takes a couple of my friends and me out for dinner, and they refer to me as Howie because that's still what I prefer. And he had a couple of drinks, and he pulls me aside, and no one else heard this, but he says to me, "I wish I had named you something else." What am I supposed to do with something like that? So now, not only do I prefer Howie, but I still use it just to kind of stick it to the guy a little bit. Anyway, my name is Howie Michael, and this evening I'm going to be talking for a little bit about trade dress, particularly product configuration marks, and I'm also going to be talking about the functionality doctrine. Now, in some respects, the marks that Scott was talking about, descriptive terms that acquire secondary meaning, and product configuration marks, face similar challenges. They're both often regarded as weak by both the courts and the Patent and Trademark Office. They're both often difficult to acquire due to secondary meaning requirements, and they're both often difficult to enforce because the scope of the right is almost presumptively narrowed. In addition, in both cases, it's constitutional considerations that serve to restrict the trademark right. For descriptive terms, of course, the issue is the First Amendment. For product configuration marks, it's the Patent and Copyright Clause. Now, many attorneys are not familiar at all with the concept of product configuration marks. So first, what I'm going to do is I'm going to define the term, and I'm going to provide some examples so that everyone understands what it is I'm talking about, hopefully. I'll then get into a discussion of the functionality doctrine, and the functionality doctrine is the constitutional issue. The functionality doctrine addresses the interaction between the trademark right and the patent and copyright clause of the Constitution. And finally, I'll conclude with a couple of practice tips. Now, this first slide here is the generally accepted definition of a trademark. And I just pulled this definition right from the Trademark Act, the Lanham Act. And the reason why I did is just to emphasize the very broad nature of the definition of the term. A trademark can conceivably be just about anything that can function as an identifier of source. It can be, for example, a product name or a slogan or a tagline, but it can also be things like sounds and jingles. A trademark can be a color, and it can be what's referred to as trade dress. Now, this is one common definition of trade dress, which I pulled from a recent decision here in the Northern District of Illinois. There are other variations of the definition, but I think that this is a good one. In my opinion, the important thing to remember when it comes to defining trade dress is, in addition to its attribute as a source identifier, trade dress can be divided into two categories: product packaging trade dress and product configuration trade dress. Now, here are some examples of the first category. This is product packaging trade dress. So you'll see here we've got in the upper left-hand corner McDonald's Big Mac sandwich packaging, Tide detergent, Morton Salt in honor of Winnie, Coca-Cola soda, and Reese's peanut butter cups. In my opinion, these are all distinctive product packaging for well-known products. Now, short of a consumer survey or a court order or a decision from the Patent and Trademark Office, whether a particular trade dress is distinctive or not is somewhat subjective. In my opinion, one good test is to imagine the product packaging without the name prominently featured. And if you'd still recognize the product, then the trade dress is probably fairly distinctive. So, for example, even without the name Tide on the Tide packaging, consumers of laundry detergent will likely recognize this packaging as a Tide product due to the color shade and the circular patterns on the front of the packaging. Likewise, regular candy eaters like myself will almost certainly recognize the orange coloring with the yellow and brown lettering and the rectangular package as Reese's peanut butter cups. On occasion, the functionality issue, the constitutional issue, comes up when dealing with this first category, product packaging. But more often than not, it comes up when discussing the second category, which are product configuration marks. This slide shows examples of valid product configuration marks. They've been deemed valid by either a court or the Patent and Trademark Office. Now compare the trademarks on this slide to the slide that we just looked at a minute ago. There's no product packaging here. Here, the trademark right is the configuration of the product itself, or at least an element of the configuration. For example, in the very center is a round-shaped thermostat. The product configuration, the enforceable trademark right, is the circular shape of the thermostat. Likewise, the goldfish-shaped cracker. There, the enforceable trademark right is the configuration of the goldfish. For the Rubik's Cube, it's the color, the patterns of the colors. For the Zippo lighter, it's the outward shape of the lighter itself. I wanted to also point out one interesting example of a different type of product configuration mark, and that is the example in the upper left-hand corner. That's a KitchenAid mixer. And you're probably looking at that and wondering, well, what aspect of that can be protectable as a trademark? There is one element of the configuration that is. If you'll notice toward the top, there's a ribbon that rings the top of the KitchenAid product. It's a stainless steel ribbon. And KitchenAid has worked very hard to get consumers to associate that ribbon along the top with its products. And in fact, if you go to a store that sells kitchen appliances, I think you'll notice it's easy to pick out the KitchenAid products because so many of them have that ribbon along the top. Now, in any event, it's with this type of trade dress, the second category, product configuration, that the constitutional concern most often comes up and the functionality doctrine comes into play. The functionality doctrine polices the division of responsibilities between patent and trademark law by invalidating marks on useful designs. Or other courts have sometimes put it another way. Trade dress is not valid as a trademark if it provides a utilitarian benefit. And if that standard sounds familiar to you, it could be because it was borrowed from some copyright law. Now here I've provided the patent and copyright clause from the Constitution. And that's Article 1, Section 8. This provision has been interpreted by the courts a number of times, including the Supreme Court. For our purposes, I want to focus just on the underlined, bolded portion. The Constitution only authorizes Congress to protect invention for limited times. Currently, utility patents have a term of 20 years from the filing date. Compare that to a trademark right, which is conceivably unlimited in time so long as the mark is in use. The key goal of the functionality doctrine is to separate the spheres of patent and trademark law and to ensure that a term of a patent is not extended beyond the period authorized by Congress. Some courts have referred to attempts to secure trademark rights for useful designs as an attempt at a backdoor patent. That happens sometimes when owners, for whatever reason, don't apply for patent rights, or perhaps they were refused on statutory grounds, or perhaps the utility patent even expired. Owners then attempt to use the trademark laws to protect that same invention. A design is functional if it is essential to the use or purpose of the article, or if it affects the cost or quality of the article. Now, going back to my examples of product configuration marks that have been deemed valid, there's nothing useful or utilitarian about the round shape of the thermostat. In fact, it could be virtually any shape. It could be rectangular, it could be a triangle, and it would still function the same way. The thermostat would still function the same way. And it's on that ground that that configuration is deemed a valid trademark. Likewise, for the goldfish, although my kids have vehemently disagreed with this, there's no functional purpose for the cracker being shaped as a goldfish. It could be shaped as a flower or as a dinosaur, and the quality and the function would still be the same. Sometimes it's easy to determine if a configuration is functional, like, for example, the thermostat or the goldfish cracker, but sometimes it's more difficult. In those cases, the Seventh Circuit has set forth the following factors to determine if a design is functional. First is the existence of a utility patent. Second, the utilitarian properties of unpatented elements. Third, it looks to advertising touting the benefits of the design. Fourth, it looks to alternative designs. And fifth, the effect on quality or cost. Now, the first factor deals with utility patents. If a design is covered by a utility patent, that constitutes strong evidence that it is useful and therefore not entitled to trademark protection. I'm not sure if you can see the picture I have here, but what that picture is an excerpt from a patent from a case that our firm recently handled. In that case, we represented the defendant, and the plaintiff asserted a claim for infringement of a product design under the trademark laws. Now, this is an extract from one of the plaintiff's utility patents. The utility patent identified the configuration as one of the preferred embodiments. And in that case, the court ruled that that constituted strong evidence that the design was useful and therefore functional. The second factor focuses on unpatented elements. Here's an example I borrowed from a case addressing this issue. The configuration of a wheel and a drinking glass are obviously useful features. They therefore weigh in favor of a finding of functionality, even though neither is covered by a utility patent. The third factor focuses on advertising. Advertising of the item that touts the utilitarian advantages weighs in favor of functionality. And I've provided here just a very brief example. Imagine a razor with a very distinctive looking handle. If the advertising touts that handle promotes comfort to the user, then that would weigh against a trademark right and in favor of a finding of functionality. The fourth factor focuses on alternative designs. A court is more likely to conclude that a design is functional if it is difficult to create alternative designs. And the fifth factor focuses on the effect on quality. A court is more likely to conclude that a design is functional if it serves to increase quality or decrease costs. Now I'll conclude with a couple of practice tips. First, consider product configuration rights. Some of your clients right now may have protectable product configuration rights and don't even realize it. And it's interesting that many times these rights almost evolve over time without anyone giving much thought to them. You're selling a product for years. Over the years, you maybe start selling complementary products. The products evolve. And you look back and you notice the similarities. Sometimes there are things that weren't even planned, but a lot of times these similarities don't provide any useful feature. These similarities are often what can form the basis for a protectable trademark right, product configuration. If you're in that position, consider broadening and strengthening those rights, perhaps by filing for trademark protection with the Patent and Trademark Office. Second, be sure to coordinate your trademark filings and your trademark positions with your patent attorneys. Don't get caught in a situation where your claim for trademark protection is undermined by one of your utility patents. This is an overlooked advantage sometimes of using the same firm for both your trademark and patent attorneys. The attorneys work together, they know what they're doing, and they talk to one another. Likewise, if you're going to assert a claim for infringement of one of your product configurations, make sure that you check your utility patents first to confirm that the configuration is not covered by one of the utility patents. And finally, carefully review your promotional materials. If the goal is to protect a product configuration, claims in your advertising that tout utilitarian features can undermine your argument. And sometimes this happens years later. One thing I found is that folks in the marketing department often have short memories. And you can explain to them why it's not advantageous for you to have utilitarian benefits promoted in your advertising. But over the years, people change. They want to come up with new types of programs, new types of ideas to promote products, and they'll come up with utilitarian advantages to your products, even if they didn't exist the first time around. That's all I have right now for trade dress and functionality. I enjoyed speaking this evening, and I hope that you found this informative, and I'll be happy to take questions at the end. Our final speaker of the evening is Winnie Kuo of Morton Salt. Winnie has some thoughts on dealing with the subject of weak trademarks from an insider's perspective. Thank you.
Okay, thank you, Howie, and good evening, everyone. As Howie mentioned, I will be sharing a in-house counsel perspective on some of the issues that both Scott and Howie have discussed so far. So to begin the discussion, we thought it would be helpful to start out with a hypothetical. In this case, you are in-house counsel to a company called Spice Brand Spice brand is putting out a new product, which is an hourglass-shaped spice dispenser, and its unique feature is that it can hold 2 spices at one time. So you can put salt on the top and pepper on the bottom. As you can expect, marketing has some great ideas for promoting this product, and in that process, for sake of our hypo today, they've come up with 4 possible ideas for this product. One is salt and pepper shaker with a flip. The second one is duo spice. The third one is taste delicious, and the fourth one is something to do with the hourglass shape of the product. So in particular, marketing wants to know, can we use this mark, can we register it, and how long will it take? And what is your recommendation? And I can tell you that this hypo does represent the typical kind of question that I get on a trademark type questions that I get in my practice. Usually the questions come from marketing. Usually the list that they have is quite long. They may have 20, 30 different ideas through their brainstorming sessions. And I think that the issue of weak trademarks comes up quite naturally because I believe, as both Scott and Howie had mentioned earlier, the list that marketing comes up with usually is a very descriptive list because I do want to say how great the product is. But the problem with that, as Scott mentioned earlier, is from a legal perspective, the more descriptive terms that are used, the weaker that is as a trademark to protect. So in this kind of situation, before I even give a recommendation, I follow a 3-step analysis process. And in this process, I really want to ask the question, should we even be pursuing this trademark at all in the first place? And if we decide that we want to pursue it, can we register it? And the last option is that if trademark registration is not possible, what other options do we have? So I think the first step in this process is the most important one as an in-house counsel person. Now, in looking at this, the main question I asked the marketing team is, what are you planning on using this trademark for? And the reason why I asked the question of use is because ultimately, if we are going to get trademark registration, we have to show use. And so, for example, if the idea that they have is only intended to be a short-term use, let's just say we're rolling out a special promotion for the Christmas season, and it's only going to be a short seasonal product, then the term that's proposed may not be appropriate for trademark registration because by the time you go through trademark registration, the promotion is over, and we're not planning on using that term again. So that's why the short-term versus long-term issue is one that I ask. I also ask where it's going to be used because if it's going to be in print ads, packaging, etc., that kind of lets me know, is this something that we're going to plan to use on all of our branded products over all the product lines, or is it just for one specific product? Again, I'm kind of looking forward to thinking about if we are going to get trademark registration, what class of goods are we going to register that trademark in? So some of these questions are to weed out those kinds of things. But the first one is, is it too descriptive? If it's truly something that's so descriptive, as Scott was discussing earlier, we're not going to be able to get trademark registration. And so in that kind of sense, you don't want to go down that path where you've spent lots of time and money pursuing an option that's really not a reasonable option for you. The other point that I wanted to make, though, is that if the idea is something that's still strong enough for your company, even though it is descriptive, then we may still need to keep it on the list, because if it is something that's important enough to the company, then we're going to have to talk about some other options that we can do to protect, use of that particular phrase, and we'll talk more about that in a later example. So this is step one, understanding what the context says. The second step is also just making sure the mark is available for use. So this slide really addresses the idea of making sure that what we're planning on doing is not going to infringe on someone else's existing mark. And in that analysis, as an in-house counsel person, at no cost really, you can do an internet search first yourself. So oftentimes in my experience, I'll go ahead and go to the federal USPTO site, run a quick trademark search just to see, overall what's out there. And also we'll do an overall general internet search as well, just to see what is out there. One example that came up in my practice actually is that our marketing team was considering a particular ad design that involved making snow angels in the snow, and it was going to be used, in connection with our ice melt product. But luckily, in doing an internet search, we noticed that a competitor had a very similar. They didn't make snow angels in the ground. I think they just, it was just a normal people playing in the snow. But the pictures looked so remarkably similar that that's something that you probably wouldn't think to check. But actually, that by doing just a simple internet search, we quickly cross that idea off the list. So I think these are just two easy ways that as an in-house counsel person you can do to sort of clear off, the low-hanging fruit, if you will, the stuff that you can kind of mark off the list. But of course, as Scott, I think, was also mentioning, if it is still important enough to you, if it's a descriptive term or even if it isn't, you still may want to go then seek outside counsel to do a full comprehensive trademark search. And again, I would definitely do that kind of search for any mark that you plan on using for all of your products. So if the use is going to be for your entire brand, then that's something that needs to be elevated, and you would definitely do a more thorough search, even if you found nothing of concern in the two initial steps here. Okay, so once I do those two steps, then we determine, do we want to register it? So let's just assume the mark is probably going to be registrable, and we decide that, we want to, we're not infringing on anyone else's mark. The question is, do we want to register it? Well, then that's a cost-benefit analysis, and I think as everyone in the room will know, that's pretty important in these days and times. And sometimes I think initially when a marketing comes with an idea, they'll only look at the initial cost, like how much is the filing fee to file the trademark. But you also have to think about how much it's going to cost to maintain that trademark over the life of the trademark. So it's not only the initial trademark filing fees, but it's also, registration, outside counsel if you use outside counsel, maintenance fees, and also the part I didn't list here is enforcement. So if it's something that, you need, now that you have a trademark that's registered, then you're going to want to make sure that you enforce it and have enough resources and time that you can monitor that appropriately. Assuming that the costs make sense and, obviously there are obvious benefits, these two are the main ones that obviously you would be the only one that could use it in your class of registered goods, and there's also increased brand awareness. So, working for Morton Salt, obviously one of the advantages is that if someone shows the Morton grill, people automatically know that it's Morton. Like, we have such a strong, sometimes arguably our mark is stronger than our company, I think, in terms of size. I think a lot of people think Morton's a lot bigger than it is because the mark is truly famous. But, quite frankly, from our company, I think in the U.S. our company maybe has like 3,000 employees, for example. But I think people think, Morton's much bigger because our brand has really surpassed, has become famous in my opinion. So. Okay, so the next step is, once we go through that pre-clearance step, we now get to trademark registration. A lot of this will echo what Scott talked about earlier, but we thought going back to the hypo, we wanted to look at these examples and say, are these marks that could be registerable? The first one, salt and pepper shaker with a flip, not likely registerable. And the reason why we included this as an example is it's very descriptive. It just basically says it's a salt and pepper shaker. You can flip it two different ways. So that's likely not registerable. The second example is a little bit more creative, but it's still kind of descriptive, right? Because dual spice kind of implies there's two different spices, but it is a little bit more creative and not literal. So in that sense, it could be registerable if we can show secondary meaning. So you'd have to do all the steps that Scott had talked about earlier, trying to, advertise and do all these things to get folks to start associating dual spice with the hourglass-shaped container that we in our hypothetical example. The third example, Taste Delicious, is an example of a fanciful, arbitrary, whimsical type name that you might not first, when you see it, identify it with a salt and pepper shaker or a spice dispenser. So we threw that in as an example of something that would probably be likely registerable immediately. And the fourth example was to tie into Howie's presentation earlier about product configuration. So perhaps the hourglass shape, could start to be identified with our spice dispenser if upon showing the secondary meaning, according to the guidelines that Howie had explained earlier. And if you have questions on that part, I'll direct them to Howie at the end of the presentation on the product configuration. So the next slide we have is alternate options. So oftentimes marketing is really pushing you, and they say, and finally, you go through all this analysis. Let's just say we can't trademark it for a lot of different reasons, or we choose not to. Well, then they'll ask me, well, what else can we do? And that's probably the most common question you'll get. And these are some ideas that we have. A lot of it echoes what was on Scott's slide, but the first one is used as a common law mark without applying for federal registration. So in that case, if we did use a mark, we would put the TM next to it, because obviously we can't put the registered R, but then we would still use it and hope to get some rights. But we would counsel the marketing team to realize that the rights are much more limited, obviously, than a federal registration. The second one, used descriptively, goes to the concept that if you are going to use a descriptive term, use it in its normal meaning, a normal part of a sentence. So, and I'll have an example of that in the next slide. But basically, it's the idea that we're not using it as a trademark, but we can still use those same words to describe our product. And maybe we can do other things in the ad or whatnot to really make it persuasive in promoting our product. The next element is adding a distinctive element. So a house mark would be, for example, adding the name. So for a Morton example, we would add the name Morton, for example, or adding another distinctive term or a logo that would help make what maybe wasn't going to be a trademark originally, perhaps, increases the chances of it becoming more like a trademark and maybe possibly being able to register the new, distinctive trademark idea. The last option is really just to say that if you really exhaust all the trademark related options, then maybe there's other options like copyright, which, for example, if you want to just protect an ad, just to make sure that no one else can use that particular ad, then we would put the copyright attribution at the bottom. So that would be a way to help protect someone from copying the ad, but at the same time not undergoing through a trademark registration type process. So with that, the last slide I have is kind of we thought would be a good descriptive example, and this is a true example. We created this, and inside the packet was a sample of sea salt. So in this example, she sells sea salt by the seashore. I'm glad I didn't get tongue-tied on that sentence, but it's a descriptive sentence, right? I mean, it just basically states something plain. However, on this particular card, we added the Morton Grill to the left, which is a registered trademark of ours, so we have the registered R. And then we extended out the salt part of it into a wave at the bottom to kind of replicate a sea. Well, we didn't trademark the phrase at the top, like I said, it's descriptive, the sentence. We didn't trademark that. We didn't trademark this little sea waves thing at the bottom either. But the marketing team was still happy because we came up with this design. They're still able to use it. And quite frankly, I mean, no one's really going to copy this design. If they are, they wouldn't be able to use the Morton Grill, right? Because that part's registered. So I think we felt pretty confident that we didn't have to go try to get, trademark registration of the C, this part here, this section here that goes across. So it's just an example, but we did put a copyright symbol on the back. So in this kind of case, I thought this just was a good example to kind of wrap up how you can still, I guess, give marketing what they want and try to, really get at the end of the day, being able to promote the product, but really trying to manage expectations and realizing the proper use of what a trademark is and not having to always go out and trademark everything. I think that's something that over time and really understanding what the proposed use of the proposed term is really helps us to counsel the marketing team appropriately and also to educate them. So one nice thing that I like about working on trademark stuff is that as you're working with the marketing team more and more, they get more comfortable with you and they'll start sharing with you more things. And so a lot of times, even now, I think I've got our team sensitive enough that even if they don't think there's a trademark issue, they will still ask. So for example, I think in one case they wanted to put a globe logo or something onto something else. And typically in the old days, they wouldn't have asked me that question. Can we put this globe on this picture? Because they just would assume a globe is just a globe. It's nothing special. But now, they know to at least ask the question because oftentimes something that can be a really plain word that you think has not been trademarked or is so descriptive really could be owned by someone or could be, limiting in some way. So with that, that's our last slide. So with that, if you have any questions for any of us, Scott, Howie, or myself, I don't know. I think we might have 5 minutes for questions. 5 or 10 minutes for questions, for any questions. So are there any questions? Yes.
If you use that descriptive term, you would probably only have protection over the house mark, correct? And I only asked this because I was just dealing with this like 2 weeks ago, so.
It would,
You want to take that one?
well,
Sure.
Sure. If you have if you have a descriptive trademark and you go with the technique of adding the house mark to
Exactly.
it, how much protection would you have against a competitor that wanted to use the descriptive term?
Exactly.
I think it would depend on the example of what they're doing and how prominent they're using it. But you're correct. There's a difference between sort of legal protection, what a court would do for you versus what the competitor may do.
And kind of drawing the line in the sand.
Drawing the line in the sand. Like I said, it really does help if when you're sending a cease and desist letter, you can put a registration number in it and refer them to a federal registration, that even if it incorporates your house mark with that descriptive term, that really helps a lot in a rhetorical sense when you send the cease and desist letter.
So essentially, it's a little bit of muscle up front, but on the back end, if it was actually challenged, it probably
would be, exactly. It would also depend on what that registration says. Did you disclaim it? Did you disclaim the descriptive term? It would depend on how they're using it. I mean, are they really using it in the middle of a sentence, in its true descriptive sense, or are they using it in a more distinctive way? And then also, a lot of times what happens is, what I was talking about, they don't just do that. They'll sometimes use a somewhat similar font or colors. So you really want to look at the entire product.
To the next level.
Yeah, to take it to the next level and to see if there's some other things that you can hang that cease and desist letter on in addition to the mark.
Okay.
So it really does depend, because let's say you have house mark descriptive term registered, and they use that descriptive term in a really obvious way, in a really distinctive way on a directly competing product to yours. That may be a different, you may feel better about going after that than if they're using it in the middle of a sentence in the way that it's a really in its true descriptive sense.
Yeah, and the other part that I would add is I think the issue really is there likelihood of confusion. I mean, that's how I would look at it from an in-house counsel perspective. And so in some ways, when you add your name to it, to me, there's no, I mean, if you say like, I don't know, Better Water starts here with Morton, I'm just making this up, then with Morton, to me, I would argue, if someone had the term registered, Better Water starts here, I'm just making this up again, hypothetical, but Better Water starts here, and then we wanted to say Better Water starts here with Morton, I would argue we're just using it as a normal sentence. But I would also argue there's no confusion there because we say with Morton, so the person reading that sentence would not confuse that with, a competitor product, right?
Right.
I mean, that's the argument I would make, at least
from a defensive standpoint.
Yeah.
Right. It really depends. I guess the overall answer is it really does depend on the circumstances and what's happening, because if people are being confused, if the people in the field are coming to you and saying that, this is a real problem, and they explain why it's a problem. They say that, people don't get, on the front of the package, you're only seeing, the same mark. You're not seeing the part with Morton. You know what I'm saying? So it really is a fact-intensive thing. That's when I was saying that, we'll look and see, is anybody being confused by this? Are people coming to you? Are you getting emails, phone calls?
But when you're starting out the process of looking at whether or not you want to register something, and it's something that your marketing department really wants to register, but it's definitely descriptive, putting a house mark on, would you recommend something like putting a house mark on it or using it for a year with just a TM symbol and kind of building up some common law and other strength to it, or would you recommend registering it and maybe disclaiming?
Okay, so the question is, if you've got a really descriptive mark, is there a preference or a recommendation to either add the house mark to it, to use it by itself and from a common law standpoint for a certain amount of time? Another option that we didn't talk about is the supplemental register, and that's from more of a technical trademark standpoint, but that's where you can register marks that are descriptive but that are capable of becoming distinctive over time. It's such a hard question because it really does depend on where the company is, how much is in their budget for this mark. Like Winnie said, is this going to be something that goes across a number of brands, or is it going to be a standalone brand? It really does. It is really fact dependent on the circumstances around it, because I've recommended all three of those things to different clients depending on what they tell me. Certain times I'll say, you know what, why don't you just use this for a year or so and see what happens with it? Does the product take off? Do we get incredible sales and great advertising, and then maybe we want to do an application?
Right.
Or I'll say, this is just never going to do it. Let's put a house mark with it and just move on.
Yeah.
And then other times they'll say, well, we want to get the R in a circle, and if you're on the supplemental register, you can use the R in a circle. And so they'll say, let's just file anyway, even if we can't make it on the principal register, which is for inherently distinctive trademarks. I've recommended all three, depending on what the client's specific situation is.
Thank you. I appreciate it.
Anything else? Okay. Hey, well, thank you very much.
Thank you.
Just on behalf of ACC, I just want to thank Scott and Winnie and Howie for an excellent program. I think we all learned a lot. And Brinks, thanks again for sponsoring it. Thanks, guys.